Okay, Mr. Brzezinski, are you able to hear me okay?
Yes, can you hear me all right?
Yep, thank you. Okay, we're on the record for the friend of the court docket this morning. The first case I have listed is Sewell versus Moore. That's case number 2018076, set for hearing at 9 a.m. On a suspension of recreational license for failure to pay child support. I don't see any of the parties on that file in the Zoom waiting room. Mr. Brzezinski, how do we want to proceed on that file today?
The front of the court be seeking to suspend the defendant's recreational license. He has a support obligation of $317 and an arrearage of $13,278.60, and the last payment received was on March 17th of 2021.
Okay, and what did you say the monthly obligation is? I'm sorry.
$317.
Okay, so this was set for a hearing today. The respondent did not appear to contest the petition. Based on the statements of Mr. Brzezinski, it appears that the statutory requirements are met for suspension of the license. So the court will grant that relief. And then will you just send over an order on that?
Yes, I will, Your Honor.
Okay, thank you. The other file I had was Ellery versus Blankenship, case number 2218849. Again, neither of those parties has appeared here today for the 9 a.m. hearing. How did you want to go forward on that file?
This hearing was adjourned from October 11th after the defendant failed to appear before the referee. He has a support obligation of $203 and an arrearage of $4,348.50. There have been no payments received on this case since the order entered, so the front of the court would ask for a bench warrant in the amount of $1,200, which includes $100 for court costs.
All right, thank you. Based on the payer's failure to appear this morning, the court will sign that bench warrant once it's presented. And that was all I had. Did you have anything else on your docket?
No, that was it.
Okay. All right, thank you. You're free to remain connected if you want. And the court will be in recess until 9:15, which is the time of the next hearing.
Okay, thank you.
Okay, Mr. Goddard, if you can unmute. Can you hear me okay, Mr. Goddard?
Yes, sir.
Okay, and Ms. Fowler, we're going to need you to connect the audio. There we go. And can you unmute?
There we go. Sorry about that.
Oh, that's all right. Thank you. Okay, we're on the record now in Goddard versus Fowler. This is case number 2218909. The record should reflect both parties are present here today by Zoom video. This is set today for an objection to referee's recommended order. And Mr. Goddard, you filed that objection. And so what are you asking the court to do, Mr. Goddard?
To restore my rights with my daughter, 50-50 legal and 50-50 physical custody. That's the way it was. Allegations were made against me from my stepdaughter. She ended up telling the truth. All charges were dropped. Child Protective Services withdrew from the case, and I would ask that my rights be restored to my daughter, Sophia.
So looking at the hearing that you had with the referee, part of the basis for the referee not granting that was the order in the probate case that's still in existence that prevents you from having contact. Are you aware of that order?
Can you hear you?
I'm sorry, you weren't able to hear that? I'm sorry.
Oh,
Okay, so part of the reason in reviewing the file, part of the reason why the referee didn't grant that relief is that order that's still in effect in the probate case with Judge Cooper that prevents you from having contact with the child. Are you aware of that order?
that order no longer exists. That case has been closed now for well over a month.
So
The same-
I checked with the probate court on Friday and they said the order is still in effect.
No, I've got the paper. They've done closed the case out. Child Protective Services closed the case and withdrew from the case. My rights have already been restored with my son. I just had to wait till this court date. But that case is closed.
All right, Ms. Fowler, what's your position on this?
Yes. That case has been closed. I was actually in attendance via Zoom for that case as well.
Okay, so what's your position with regard to Mr. Goddard's request for 50-50
I'm okay with-
custody?
I'm okay with it going back to 50-50.
Okay, all right. So what the court will do then is I'll issue an order today reflecting that the custody should go back to the way it was previous. And that's based on the agreement of the two of you here on the record.
50-50 legal and physical, Your Honor.
Right. Okay. So I'll issue that order today. If you want to check with the friend of the court, obviously you won't be able to get a copy of that today because I may not get to that until the end of the day here today because I have a full docket. But if you want to check with the friend of the court starting tomorrow morning, if you want to get a copy of that order, it should be filed at that time.
Okay, thank you, Your Honor.
Okay, Mr. Goddard, did you have any
Thank
other
you.
questions?
No, we're fine. Thank you.
Okay, Ms. Fowler, did you have any questions?
No, sir.
Okay, all right, thank you. You're both free to disconnect at this time.
All righty. Have a good day.
Thank you.
Thank you.
All right, Miss Willetts, are you able to hear me okay?
Yes, sir.
Okay, were you expecting Mr. Willetts to join the hearing today?
Yeah, he should be
Oh,
coming
there
in at any time.
Okay, 1 second. Okay, Mr. Willetts, I'm just gonna need you to unmute, please. Mr. Willetts, are you able to hear me okay?
Yep, I can hear you now that I remembered I had headphones plugged in.
All right. Okay, we'll go on the record then in Willetts versus Willetts. This is case number 2319323. The record should reflect both parties are present today by Zoom video. This is set for a hearing today to enter a judgment of divorce. Mr. Willetts, is that how you wanted to proceed today?
Yes, sir.
And Ms. Willetts, is that how you wanted to go forward?
Yes, sir.
Okay, so I'm going to place you both under oath. I've got some questions that I need to ask both of you. The questions I'm going to be asking are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both please raise your right hands. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. You can lower your hands. Mr. Willett, as the filing party, I'm going to start my questions with you. Mr. Willett, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes, it is.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
Okay, and there was one child born of the marriage, Branson, is that correct?
Yes, it is.
And by agreement, you and Ms. Willetts are going to share joint legal and physical custody and have an equal number of overnights with your son, is that correct?
Yes, it is.
Okay, and then based on that, there isn't going to be any payment either way of child support in this case. Is that your understanding as well?
Yes.
Okay, and with regard to the assets or debts of the marriage, you and Ms. Willetts have reached agreements as to how to divide up all the assets and debts, and you've put that in writing and signed that. Is that correct?
That is.
And by signing that document, does that reflect your intention to agree to and abide by the terms of that agreement?
Yes, it does.
Okay. As part of that agreement, neither of you is going to receive any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
That's correct.
Okay. Do you agree that there remain no issues regarding either custody, child support, or the division of assets or debts that remain for the court to decide?
You're right. Yes. We're good.
Okay.
Yep.
Thank you. Ms. Willetts, have you heard all the questions that I asked Mr. Willetts?
Yes.
Did you hear all the answers that he gave?
Yes.
Do you have any reason to believe that any of his answers were untrue?
No.
Are you currently pregnant?
No.
And with regard to sharing joint custody, legal and physical, and with regard to the equal number of overnights with your son, do you agree to all of those provisions?
Yes.
And the settlement agreement regarding the assets or debts of the marriage that I mentioned, you've read through that and you've signed that as well, is that correct?
Yes, sir.
And by signing that document, do you agree to abide by all the terms of that settlement agreement?
Yes.
As I indicated, you would not be receiving any alimony or spousal support. You also understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes,
And do you agree that there remain no issues regarding custody, child support, or division of assets or debts that need to be decided by the court?
yes. No.
Thank you. You agree that there are none remaining?
Correct.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court has reviewed the proposed judgment as well as the settlement agreement, and the court finds that they contain all the provisions required by statute and court rule, and that it is otherwise generally equitable. The court will grant the divorce. I'm signing this judgment here today. Ms. Willits, are you asking to have your last name changed?
No.
Okay. All right. Mr. Willits, did you have any questions at all?
Nope, not that I know of.
Okay, Ms. Willits, did you have any questions?
Nope.
Okay, thank you. That's all for this hearing today, and both sides are free to disconnect.
Thank
Thank you.
you.
Mr. House, are you able to hear me okay?
Yes.
All right, and Mr. Rolla?
Can you hear me?
Okay, I can, thank you. And Ms. House, are you connected as well?
Yes, I am.
Okay, we're on the record in House versus House. This is case number 2319367. The record should reflect all parties are present today by Zoom video. This is set today for entry of a default judgment of support for the child rebel Anthony Cash House. Mr. Rolla, I do have a copy of a proposed judgment here. Was there anything that you wanted to state for the record in support of that today?
Judge, the conditions for entry of a default have been met. The court has copies of proofs of service and documents and/or non-responses by Mr. House as required by law. In the best interest of the child, I think it's appropriate that the order be entered. Should the court choose to take some additional testimony from Ms. House, that would be appropriate. Thank you, Judge.
All right, thank you. Ms. House, you're the mother of Rebel Anthony Cash House, is that correct?
Correct.
Okay, and you understand that this order would provide that you would have joint legal and physical custody of your child with Mr. House, and that would also provide for Mr. House to pay child support in the amount of $105 a month. Do you understand that?
Yes, I do, Your Honor.
As the mother of this child, do you believe that entering these orders today would be in the best interest of your child?
For the time being, Your Honor.
Okay. Mr. House, I'm sorry, were you able to hear everything that I stated?
Yes.
Are you contesting anything about the entry of this order today?
No.
Okay. All right, based on the statements of the parties here on the record, the court finds that it would be in the best interest of the child to enter these orders. So the court will sign those today. Mr. Rolla, anything else that we needed to address for the record on this case?
Not in this file. Thank you, Judge.
Ms. House, did you have any questions at all?
No, Your Honor.
Thank you. Mr. House, did you have any questions?
Yeah, just I won't be able to start paying until towards the end of this month here because I'm currently in where I'm at.
Judge, the order indicates, I believe, upon release.
Right, correct, Mr. House. Okay. And if you have questions once you are released, Mr. House, I would definitely encourage you to contact friend of the court, and they can help you get through that process of getting things going.
Okay, thank you.
Okay, thank you. All parties on this file are free to disconnect at this time. And then I do have the next case as well, Mr. Rolla.
Correct. That's Spreeman v. Edwards v. Spreeman.
Okay, Miss Edwards, if you could unmute. All right, are you able to hear me okay, Miss Edwards?
I am.
Okay, and then just 1 second here, Mr. Spreeman's connecting.
And Judge, once Mr. Spreeman knocks in for our file, we need an updated address and phone number with the court's pleasure, please.
Okay. Mr. Spreeman, are you able to hear me all right?
I'm trying to figure out the video. I do hear you now.
Okay. Okay, we're on the record in Edwards versus Spreeman. This is case number 2319466. We're set here today for entry of judgment of affiliation. And Mr. Rolla, again, I am in receipt of a proposed judgment. Was there anything that you wanted to state for the record here today?
Judge, as with the last case, the documents with proofs of service are in the court file. It's my understanding Ms. Edwards will also provide information to the court that entry of the order is in the best interest of the minor child. That is the position of the people, and we'd ask the court to sign and enter the order. Thank you.
Okay, so Ms. Edwards, you are the mother of Braxton Allen Edwards, is that correct?
Correct.
Okay, and you understand that the order the court would be entering today is establishing Mr. Freeman as the father of Braxton, and that it would provide for sole physical custody with you with parenting time for Mr. Freeman as you agree, and then joint legal custody and payment of support. Do you understand those things?
Yes, I do.
Okay, and as the mother of Braxton, is it your opinion that entry of this order today would be in your child's best interest?
Yes, I do.
Okay. Mr. Freeman, do you acknowledge that you are the father of Braxton Allen Edwards?
Yes, Your Honor, I do.
Okay, and are you contesting entry of the order here today establishing that?
No, Your Honor.
Okay. All right, so the court finds that all the statutory grounds have been met, and based on the statements of both parents today, the court finds it would be in the best interest to enter the order, so the court will do that. Mr. Rolla, anything further that we need to address for the record today?
Yes, Judge, updated current address and phone number for Mr. Freeman.
Sorry, I forgot all about that. Mr. Freeman, could you give us an updated address for you? The one we have is on Mount Vernon Hills in Vanderbilt.
That is my address, Your Honor.
Okay.
I'm not always there depending on where I'm working.
Work address then, Judge, or employer's name?
Not an employer. I do work for myself.
Do you have any other address that we would send mail to, Mr.?
That's where I get all of my mail, Your Honor.
Okay. Okay, so we'll just continue to send things to that address at Mount Vernon Hills in Vanderbilt. That's all I have for the record.
Judge, valid phone number then? I don't know what he's called in on.
Okay, Mr. Freeman, can you give us a phone number for you?
Yes, Your Honor. 989-370-7193.
Thank you, Judge. Thank you, Mr. Freeman.
Yes, sir.
Okay, thank you. That's all for today. All parties on this case are free to disconnect at this time.
Thank you.
Our next hearing is set for 10 o'clock. The court will be in recess until 10. Okay, Mr. Wilkinson, are you able to hear me okay?
Yes. Can you hear me?
I can, thank you. And Ms. Wilkinson, if you can unmute, there we go. Okay. All right, we have both parties connected. This is Wilkinson versus Wilkinson, case number 2319416. Both parties are present here by Zoom video today. This is a pretrial hearing just to determine whether or not there are issues regarding the division of any marital assets or debts. It looks like the parties have already been to front of the court on issues related to custody and support of your child in this case, but just in terms of dividing up any assets or debts or property of the marriage, Mr. Wilkinson, from your standpoint, have you been able to reach any agreements on that with Ms. Wilkinson?
I feel like we've reached a good agreement about everything.
Okay. Ms. Wilkinson, do you agree with that?
Yes.
Okay. So as you both might be aware, there is a 6-month waiting period before the court can finalize the divorce. And so you filed this case in September. So the court, I think September or end of August, it looks like. So then what I would do, since there aren't any issues that need to be resolved by the court, it's just a matter of getting to that 6-month period. So what I would do is set this for a final hearing right after the expiration of that 6-month period, which should be February or March. And then Mr. Wilkinson, since you're the party that filed, I would need you to get one final form, and that's called a judgment of divorce. And you may already have it. You can get it wherever you got your forms to file as well. But that's the final document that closes the case and finalizes the divorce. So I would just need you to get that document, fill that out, and then submit that to the court prior to that final hearing. And then one other step is just to get contact the friend of the court and get a final support order from friend of the court as well.
Okay.
Did you have any questions about that at all?
Just what was that first document called again? One more time, please.
It's called a judgment of divorce.
Judgment of divorce. Okay. That's all I needed, sir.
Okay. Ms. Wilkinson, did you have any questions at all?
No, I don't have any questions.
Okay. All right. Thank you. So the court will send out a notice of that final hearing to both of you in the mail. That'll be by Zoom, just like we're doing today. So just look for that notice, and then we'll finalize things on that date. And you're both free to disconnect. Thank you.
Thank you.
Thank you.
Hi, this is whoever's on the phone with the last 4 digits, 7724. Can you tell me your name, please?
David Leonardson.
Oh, Mr. Leonardson. Okay, thank you. 1 second. Okay, ma'am, on the Samsung device, can you unmute, please? I can't, I see you're talking, but I can't hear you until you unmute.
Here, unmute. Can you hear me now?
I can, thank you. Can you tell me your name?
My name is Valerie Zampic.
And do you know what case are you calling in on?
Doyle versus Higdon. I was the court-appointed supervisor.
Got it. Okay. That is set for 10:15, so I'm just going to put you back in the waiting room until that time. Okay.
Okay, sounds good.
Thank you. All right, so we have Mr. Dundon connected. We also have Mr. Leonardson. So we'll go on the record in Tabaka versus Tabaka. This is case number 2219040. If I could just have both counsel put your appearances on.
Good morning, Your Honor. Mark Dundon appearing on behalf of Lisa Tabaka.
Your Honor, David Leonardson representing Kenneth Tabaka, the defendant.
Okay, I am in receipt of a proposed judgment of divorce. And so, Mr. Dundon, did we want to go forward with proofs today?
You know what? I apologize. My client seems to think that we already put proofs on the record, Your Honor. I'm assuming you must not have them then, Judge. Sorry, I'm just double checking.
Let me check with Susie. Susie, can you look and see if we may have? I know
Sure,
we've had a number of hearings.
Yeah, I've been dealing with a medical. I blew out my knee, so I'm working from home. Anyway, I've been having some difficulty getting to and from.
Yes, sir. It looks like we did proofs on November 6th. And the divorce was granted and it said parties to submit judgment within 30 days. And then we set a control date of the 30 days for the judgment.
Okay, very good. So, Mr. Dundon, do you just want the court to enter the judgment that was submitted here? It looks like on the 29th of November.
Yes, please, Your Honor. All we have to do is get the uniform support orders done, which the numbers are all there. So yes, Your Honor, if you could, and we'll get was on the phone with FOC today. We will get that turned around straight away.
Okay, Mr. Leonardson, do you have any objection to that?
No, we encourage the filing of the judgment.
Okay, so the court has signed that judgment, and then Mr. Dundon, yeah, if you can just have finalize that with friend of the court, and the court will sign that final support order.
Okay, thank you, Your Honor. We'll get it done.
Mr. Dundon, anything else we need to address from your side today?
No, Your Honor. Well, there's just one. I guess I have to get with Dave and figure out there was a $400 payment due December 1st, which I guess is technically now predating the entry, but I'm pretty sure I can get that squared away with Mr. Leonardson.
Okay. Mr. Leonardson, anything further from your side today?
No, Your Honor.
Okay, thank you. Both all parties on this file are free to disconnect at this time.
Thank you, Judge.
Thank you, Your Honor.
Okay, Mr. Higgs, are you able to hear me okay?
Yes, Your Honor.
All right. Just waiting for the other parties to come online here. Okay, Mr. Higdon, are you able to hear me okay?
Yes, Your Honor.
Okay. And looks like we have Ms. Doyle connected as well. So we'll go on the record. This is Doyle versus Higdon, case number 2118671. And Mr. Higgs, you're appearing on behalf of Ms. Doyle, is that correct?
That is correct, Your Honor.
Right. And Mr. Higdon, in the past, you've had Mr. Brown representing you. Is he appearing for you today?
No, Your Honor. I'm representing myself.
Okay. All right. So we're on the record here today for a scheduling hearing. Mr. Higgs, you've filed an objection to the referee's latest order, which I think was back in October 18th of 2023. Naming Janet Higdon as the supervisor for parenting time, and you've objected to that. Is that correct?
That is correct.
Okay. How much time do you think we would need for an evidentiary hearing in this case?
At most a couple of hours. We're going to provide some other alternatives that are neutral and explain why this wasn't a good choice. So it wouldn't take more than a couple hours.
Okay, so if the court set this for a 2-hour hearing, you think that would be enough?
That would be enough, yes.
Okay. Mr. Higdon, from your standpoint, do you agree that that would be enough time for the court to hear the testimony?
Yes, Your Honor.
Okay. So the court will set this for a 2-hour hearing, and that'll be an in-person hearing. So the court will set it as in-person here in the courtroom in Otsego County. So both sides can just have whatever witnesses you intend to call, have them ready to appear in person for the testimony. And then the court will issue a ruling once we've heard that testimony. Mr. Higgs, is there anything else that you can think of that we need to address other than just getting the date set today?
Your Honor, we may be calling somebody for CPS, and I know in the past in other courts they've appeared by Zoom. Should I ask for permission for them to appear by Zoom if they're going to give short testimony, or would you like them to be here in person?
Right, like my default position or the presumption, I guess, under the court rules is that they would appear in person. But yeah, if you want to request that they appear by Zoom, then again, just follow the procedure in the court rules to request that, and I don't think that'll be a problem.
Thank you, Your Honor.
Okay. Mr. Higdon, did you have any questions at all?
No, Your Honor. Yeah, no. Other than the fact that I haven't seen my kids in a month and a half, but yeah, I don't know what to do there, but all right.
Okay, so the court will send out notice of the date and time of that hearing. Both sides will get that in the mail, and then we'll go forward from there. Same thing for you, Mr. Higdon. If there are any witnesses that you want to call, then you would need to have them present here for that court hearing as well. And that's all I have for today. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Your Honor.
All right, let's see. Whoever's on the Motorola device, can you unmute, please? Hi, can you tell me your name?
Shannon Susie.
Okay, and let's see. It looks like we have Kayla Susie connected. Miss Susie, I'm going to need you to connect the audio on your Zoom app. If you go into your Zoom app, there's a button that you can press to connect audio on there. There we go. All right, Miss Susie, the other thing you can do if you're not able to navigate that is you can sign off and sign back in and just use your phone, just call in to the PMR. All right, while we're waiting for her to do one of those things, Mr. Susie, just from your standpoint, can you tell me, I know that the case is relatively new, there were some problems with service, but now we have the complaint served. Are there issues from your standpoint with regard to the division of assets or debts?
Yes. Um, between Kayla and I, we have no assets together.
Okay. Are there debts that need to be divided up?
I'm not requesting any debts to be added up or divided among us.
Okay. And just looking at Miss Susie's answer, it looks like there are some things that she's contesting. So what I'm going to do is for our typical schedule, and Mr. Susie, they're children, correct? You have some minor children?
Yes, sir. There's 4 children.
Okay. So what I'm going to do is refer this case to mediation. That's where the two of you would meet with a neutral third party to kind of talk about the issues between the two of you to see if you would be able to reach an agreement. And neither of you is required to reach an agreement, but that third party will help the two of you try to get to that point. And then the court will set it for a hearing after you've participated in that process. And Mr. Brzezinski, was there anything that you wanted to add here?
We just needed to confirm the defendant's address and contact information. But if she's
Yes.
having audio issues, then we can try another way.
Yeah, she does not appear to be able to connect the audio here. So Ms. Susie, if you can hear that, if you can contact a friend of the court office and give them your current address, and Mr. Brzezinski, can you just state the phone number there so that she,
Yeah, it's
Yeah.
989-731-7450.
okay. All right, so, and then the court will set this for another hearing after the mediation. The court will send out the date, time of that hearing. Ms. Susie, if you're not gonna be able to operate the Zoom app, let us know about that. And we can set that as an in-person hearing so that we can make sure that that we get your side of things. Mr. Susie, did you have any questions at all?
Other than, I have not actually received her response. She's claimed that she has mailed it to me and she got it back returned, but the address that was originally on file has been forwarded to a P.O. box, and all mail has been forwarded to that P.O. box. So she is not
Okay.
sending her.
Is your address the address on South Otsego?
Yes,
Okay, and you're saying that she hasn't been sending things to your address?
correct.
Okay, so Miss Susie, when you file anything with the court, you need to also send copies of that to Mr. Susie at his address on South Otsego, 2880 South Otsego. Mr. Susie, you can always get copies of anything from the clerk as well. It's all in the court file. However, you are entitled to receive copies in the mail as well. So Ms. Susie should be sending those to you. Did you have any other questions?
Nope, I have no other questions.
Okay. So the court will send out notice of hearing for that next date. And you'll also be contacted by the mediation service, and they will work with you and Ms. Susie to set up a date that works for both of you for that mediation process. That's all I have for today, and all parties in this case are free to disconnect at this time.
Do we have friends of the court on the line?
Yes. Oh, not anymore. We did.
Okay, because I have a court date for friends of the court at the end of this month for custody and child support.
Okay. Yeah, just make sure that you sign in for that date as well.
Okay. Alrighty then.
Okay. All right. Thank you.
Thank you.
Just for the record, Miss Susie's holding up a note that says that she's not able to hear. So I think for the next hearing, the court is going to set this in person. Because it appears she's having issues with using her Zoom app. So we'll just note that for the record. Okay, the court's next hearing is set for 11:30. We'll be in recess until that time. All right, Mr. K, are you anticipating anybody from Miss Matson's office appearing today?
I assume they would be here.
Yeah.
I'll shoot her a text real quick.
Okay, thank you.
It doesn't look like she knew about it, Judge. I'm trying to figure out if she can get on.
Okay.
Miss Matson's gonna have someone from her office hop on.
Okay, great. Thank you. All right, Ms. Lewis, are you from Ms. Matson's office?
I am, Your Honor.
Okay, great. So we'll go on the record. This is Kathy Niss versus Otsego Memorial. This is case number 2118627. And if I could just have both counsel put your appearances on, please.
Andrew Kay on behalf of the plaintiff, Your Honor.
Camille Lewis on behalf of the defendant, Your Honor.
Thank you. We're set today for entry of an order approving settlement and distribution of some proceeds as a result of that settlement. I did receive your motion, Mr. Kay. I've had a chance to review that along with the supporting documents, including the report of the guardian ad litem, as well as the confidential settlement terms. Was there anything that you wanted to state for the record today, or did you want to take any testimony? I see we have Ms. Niss, the personal representative, present as well.
Yeah, we can just take testimony from Ms. Niss.
Okay, Ms. Niss, if you could just unmute yourself, please. Thank you. And ma'am, hi, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Mr. Kay, please proceed.
Okay, this is a confidential settlement, so we won't be putting any of the numbers on the record. But Ms. Niss, you are the wife of Mark Niss, who is now deceased, correct?
Correct.
Okay, and you were named the personal representative of his estate, correct?
Yes.
And in that capacity, you hired our firm, McKean & Associates, to file a lawsuit for wrongful death on behalf of your husband, correct?
Yes.
Okay. During the course of litigation, we had time for settlement discussions, and we've come to a settlement agreement, which is in the confidential exhibit, which you have agreed to, correct?
Yes.
Okay. Also, during the course of litigation, there were costs that McKean & Associates paid, and those costs are in the confidential exhibit, and you agree with those costs, correct?
Yes.
There are also attorney fees that were agreed upon, and those are in the confidential exhibit, and you agreed to those attorney fees, correct?
Yes.
Okay. There's also a probate fee for you becoming the personal representative, and you agree with those fees, correct?
Yes.
And due to the fact that there is a minor of Mr. Niss, there's a guardian ad litem who we hired to do a report, and you agree with his fees, correct?
Yes.
Okay. There's also a lien for healthcare costs from Priority Health, and you agree that those liens will be paid from the settlement funds, correct?
Yes.
And Massive negotiated those liens for us, and you agree with their fee also, correct?
Yes.
Okay. You know that this is a full and final resolution of this case, and you can't come back and sue these defendants again, correct?
Yes.
Okay. You're aware that entering into the settlement, you give up your right to a jury trial, correct?
Yes.
And a jury could award you more, less, the same amount, or no money at all, correct?
Yes.
Okay, but you believe this settlement is in the best interest of the state of your late husband, Mr. Niss, correct?
Yes.
Your Honor, there were some discussions with other family members, and they were all put on notice. Some did sign waivers. I thought that one of the sons may have disagreed with how it's being distributed, but I don't see him today, and there's no one else in the waiting room.
No, there is no one in the waiting room on this case.
Okay. So then we request the distribution be paid as stated in the confidential exhibit, and you agree with that, Ms. Niss, correct?
Yes.
That's all I have, Your Honor.
Thank you. Ms. Lewis, was there any questions that you had on behalf of the defendants?
No questions, Your Honor.
Okay. Thank you. Again, the court has reviewed all the documents submitted by plaintiff's counsel in support of this motion today. I've had a chance to review all of those documents as well as hear the testimony of Ms. Niss on the record. Again, the court does note this was set for hearing at 11:30. It's now 11:43. No one has appeared today to contest entry of the order. although proper notices were provided pursuant to statute. So the court finds that the settlement should be approved and distributed as indicated by counsel. So I'll sign, there was a proposed order provided, so the court's signing that with today's date. Mr. K, anything else that we need to address for the record today?
No, Your Honor. Thank you very much.
Okay, thank you. That's all for this hearing, and all parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Okay, looks like we have all counsel present. We'll go on the record in IRT versus Cash and Carry, case number 2218977. And if I could just have counsel put your appearances on, starting with plaintiff, please.
David Spengros for Westwind and Gaylord.
Your Honor, Greg Light on behalf of defendant Chris Lee and Margaret Lee.
Your Honor, Rick Conklin on behalf of Commercial Distribution Specialists, DBA will be supply.
Okay, thank you. This was set just as a status conference today. I think it sounds like maybe there was some confusion arising out of our last meeting with regard to mediation. And I had a chance prior to today to just review the video of that hearing. Obviously, I have that luxury. I know counsel doesn't. So we did have kind of a discussion, and it just listening to it, it sounded like everyone was kind of on the same page that they wanted to do mediation, given the court's rulings and kind of the change in the landscape since the last attempt at it. And so it was the court's intent to allow the parties to have some time to do that. But now I'm not sure that the parties want to do that or think that it would be helpful. So I guess if we could just address that directly, Mr. Spengros, on behalf of your side.
Well, if we haven't had mediation already, it's probably my fault, because I was under the understanding we were going to discuss it with our clients, so whether we wanted to do it again, because I think the court is aware we did a full day mediation before we even did anything else. And as far as the issues, I think the three of us who are remaining in this case are pretty well aware of what the issues are. And I talked to my client about it, and I think we exchanged some settlement offers with Mr. Conklin a little bit and Mr. Light. And I think at this point, my client didn't feel it would be worth the money to spend to do it. Obviously, if the court's got to order it, or if it did order it the last time, I apologize for being kind of hands off on that. But I just don't see where, given the stance of the parties at this point, the mediation would, at least from Westwind's point of view, do any good. So that's basically where we stand. Okay, and Mr. Spengros, how do you want to go forward then in terms of scheduling? Do you want, I don't know, Well, we filed a motion on the remaining claim involving unjust enrichment, and I guess the claim between Westwind and Mr. Light's clients is still out there. I mean, we'll go to mediation if it's ordered, or if the parties are, very much interested in doing it and think it's a good idea. But as far as us advocating for it, I am not in a position to do that.
Do you have a hearing date for that motion yet?
It's February.
February, okay. All right, thank you. Mr. Conklin?
I think the issues have been narrowed, and I'm still of the opinion that I think mediation could be beneficial. Obviously Mr. Svengross is correct. We did mediate prior to the start of litigation. However, I think the issues have become more refined, and the parties obviously are fewer. So I think that might help with mediation.
All right, thank you. Mr. Light?
Thank you, Your Honor. I'm a big fan of the mediation process, but obviously I think it requires all parties to be willing participants and to have a belief that it can be productive. If what Mr. Svengross is telling us is that his client is not really interested in participating, I don't know if it makes sense to force him into doing it. I certainly think it would be helpful if we could resolve these claims. I think there's a possibility of doing that, but I obviously can't speak for all the parties involved here.
Okay. All right, given that there's motion set for February, let's hold off. The court's going to hold off on ordering any kind of mediation. Obviously, the parties hopefully will still continue to negotiate and discuss as we move forward. But I think it would be good to have that hearing in February, have a decision on whatever motions are outstanding, and then reconsider mediation at that point. So that's what I'll indicate for the status conference order today. The court's going to hold off on ordering mediation pending the February motions, and then reconsider that at that time. Mr. Svengross, any objection to that?
No objections, and I would just, as long as I got counsel on here, we're always willing to entertain any offers to resolve the matter.
Thank you. Mr. Conklin, any objection?
No objections, Your Honor.
Mr. Light?
I don't have any objections either, Your Honor. Thank you.
Okay. All right. So I'll do a status conference order reflecting that, and then we'll go forward in February. That's all I have for today. Thanks, counsel, and everybody's free to disconnect.
Thank you.
Thank you, Your Honor.
That concludes the court's morning docket. The court will be in recess until 1:40.